I am purchasing a property and the current tenant who is not paying rent and whose lease expires Friday. Is it possible to evict this tenant? Yes, it is possible. So, well, it depends to who is evicting the tenant. You're purchasing a property, but when are you purchasing the property? If the property isn't being purchased for, let's say, 60 or 90 days, well, then maybe the current landlord, the current owner, is the one who needs to do the eviction. Just remember, though, that an eviction nowadays could easily take, 5, 6, 8, 10 weeks, depending on the county, depending on the judge, depending on the scenario. So I wouldn't necessarily have the current landlord initiate the eviction, or if you're going to close in 2 weeks, we're going to have to dismiss that case, and then you're going to have to bring the eviction. So that's something that you need to be aware of. But yes, technically, if the lease is expiring this Friday, then that's a holdover tenant, assuming there's no other information that I don't know, and we can file that eviction next week. So for example, the Florida Realtors lease is just a 12-month lease. If that lease ends on Friday, then we could file that eviction on Monday. We don't technically need to give any notice for that if they have not vacated. So hopefully that answers your question. So I'm getting some questions about Miami Beach and Miami and South Miami and notices and 30-day notices. Let me be clear here. We're talking about possibly two different things. So if this is a non-payment of rent issue and it's not for something else like termination of month-to-month tenancy or holdover or anything like that, if it's for non-payment, you need to do the analysis of, does my property fall under the CARES Act? And we talked about those things, the reasons why it might fall under the CARES Act. For example, if your property is a federally backed mortgage, or it's a multifamily property with a federally backed mortgage and you're getting mortgage forbearance, or you have a Section 8 tenant or a tenant getting some other federal funds, and rent has accrued and you're evicting them for rent that has accrued through July, essentially, then your property falls under the CARES Act. If the answer to any of those questions is yes, therefore you would need to serve a 30-day notice of non-payment of rent using the 3-day notice form. Okay, that's across the entire United States of America. That's not just Florida, because that's a federal rule. Let's separate that. That's for non-payment of rent. What I was talking about with Miami, that's specific to Miami, and technically the city of Miami, Miami Beach, but I would say anywhere in Miami-Dade. If you're terminating a month-to-month tenancy, serve a 30-day notice, a minimum of 30 days. So if your purpose is to terminate a month-to-month tenancy, you give a quote-unquote 30-day notice right now, you would have to give them till the end of September if rent is due on the 1st of the month. If you're outside of Miami-Dade, so let's say your property is in Fort Lauderdale or in West Palm Beach or in Orlando or Tampa, you can give a 15-day notice and give them till the end of August, so August 31st to vacate, okay? So that's termination of month-to-month tenancy. That's a different type of notice. So hopefully that clears things up. Let me go on to the next question here. Thank you all. What if tenant has been adversely affected for the past months, reduced hours, loss of overtime, no unemployment wages, and fell behind since March, but is paying what they can weekly to the property manager and has then paid $2,000 2 weeks ago, but still is behind? Property manager has been relentless and borderline stalking and abusive, even when tenant is really trying to do the right thing. Now working 7 days per week to catch up. If September 1st comes up and they are still 3 weeks behind, dollar-wise, and the 3-day notice is filed and they do contest, will judge look at the fact that they were indeed adversely affected and have done all possible to pay what they can and enable time to catch up before being thrown out on the street? Well, Doreen, I would say from a lawyer's perspective, I can tell you're asking this from the tenant or the perspective of a tenant and not a landlord, but just to analyze what you said is, if this is a non-payment of rent type eviction and you or this tenant, I don't know if this is you or this is someone else, this tenant has an eviction filed against them for non-payment of rent, and the tenant files an answer for a COVID-19 related hardship, a judge might likely set a hearing for it, and then the tenant might have to prove what that hardship was, and they can prove that they were adversely affected and this affected their ability to pay rent. If this moratorium is extended past September 1st and you have a hearing, let's say on September 15th, and it's extended another month or 2 months by the governor, well, then it's likely that the final judgment or the writ of possession would likely, one or both of those would not be allowed to move forward. If the moratorium that the governor has for that COVID-19 hardship defense is not extended, then you will I say you, but the tenant will likely be evicted at that point. So hopefully that answers your question. I would say from one other thing to add to that, and Eddie can speak on this, is, you know, one of the important things, and please piggyback off of this, Eddie, but is communication by tenants and honoring your word, committing to payment dates, committing to a repayment plan. Because I can tell you, I actually own and rent out 10 properties, and my 10 properties, if my tenants are in communication, they're letting me know they have a hardship, but they're working out a repayment plan, and they're having integrity and paying according to that repayment plan, I am likely to not evict them as long as I've signed up for that payment plan, and so is the tenant. We've agreed to that. Eddie, do you have comments on that?
I totally. They're in communication and they're work out a plan. Those are the ones that we're going to work with. If communication, then those we have no choice but to move forward with the eviction.
Okay, I agree. So we're in agreement. Next question: what are your fees to file for a referral purpose? What I will do at the end of this webinar, I will email everyone a link to our website for the eviction intake form. If you do decide that you want to file with our law firm, there's very easy online. You click the link, you take a couple minutes to fill out the online intake form. You can attach your lease and or notices and upload that. We will get your eviction processed. If you upload your information in the morning, very likely, as long as everything looks good, we'll get your eviction filed the same day. Our fees, we charge a $195 attorney fee for an uncontested eviction and or an eviction that doesn't require a hearing. There is a $185 filing fee that the clerk charges, $10 per tenant that the clerk charges for the summons, and $40 per tenant that the process server charges for the service of process. That adds up to $435 for a one tenant eviction. Again, that does not include if you need the writ of possession. That is going to be $90 in most counties. In Miami-Dade, that's $115. That goes to the sheriff. And if there's a hearing, there can be an additional hearing fee for that. Let me move on to the next question. Good morning. Any chance you can or will send out the deck? Yes. The outline as well as a recording of this presentation will be sent out afterwards. It will have a password for the recording. Make sure you enter that password by either typing one digit at a time or copying the password with no additional spaces. If you add an additional space when you're copying it, it probably will say that it's an invalid password. Next question, proof of loss of employment for a tenant, what would that be? Well, I can tell you one thing we will ask for if we're representing our landlords is we will ask that the tenant show their bank records showing that perhaps back in March or April, they were earning, if they were earning $4,000 per month, for example. Well, I want to see the bank records from July, for example, or when rent became late or delinquent, to show that you're not making $4,000 a month, to show that $4,000 is not being deposited into your bank account. That's one thing that I'm going to ask as a landlord's attorney. What a judge will require or agree with, or as far as evidence is concerned, is going to be different with every judge, okay? If a lease expired June 30th and a tenant paid 2/3 of the rent amount for July, can a notice be sent to the tenant in August advising them that they are now considered a holdover? No part of the rent was paid for August. Well, so your lease expired June 30th. They paid part of the rent for July. Essentially what you've done by accepting that rent, as long as the lease doesn't have any term in it that says that it's automatically renewed for another year, but essentially what you've done is you've created a month-to-month tenancy by accepting some money for July. Therefore, you would have to serve that termination of month-to-month notice, which outside of Miami-Dade, you would be serving that 15-day notice. And if rent is due on the first of the month, you would be giving them till August 31st to vacate. Next question. I was in the midst of a commercial foreclosure case on a private note and I issued on an apartment building. Are there any issues, moratoriums that would prohibit me from continuing this foreclosure matter in Miami-Dade courts? You probably should talk to your foreclosure attorney. This specific webinar here is about evictions, not foreclosures. Very two different things. There are different rules for foreclosures. Obviously, I'm assuming if you've done a foreclosure, you're doing it through an attorney. I don't want to counter any advice that attorney may have. So make sure you ask your attorney. Next question. I deal with several cash investors, no mortgages. Is the 3-day notice applicable, or should I automatically use the 30-day? If there is no mortgage and the tenants are not Section 8, then you can move forward with a 3-day notice for non-payment of rent, and we can get those cases filed. Next question, can you collect security deposit for missed rent? I think what the question, I believe, is, just to clarify, I believe what it is can you use the security deposit towards back due rent? Yes, you can. I mean, you can make a claim, but you would need to make a claim on that security deposit once the tenant is out of the property. I guess technically you could also have an agreement if you wanted to as a landlord and do the tenant a courtesy, a favor of applying a security deposit towards some month of rent. You don't have to do that as a landlord. If you want to, again, you will be out of a security deposit and you'll have nothing to make a claim on for physical damages if you do that. But if you want to work something out in writing and sign an agreement to apply the security deposit towards past due rent, that's up to you. Okay, and Broward, how much can a landlord increase rent on a new lease? There is no restrictions in any county in Florida, as far as I know, for any rent increases in Florida. There's certainly no state issue with that, so you can increase it however much you want. Rather than make a mistake with notices regarding the CARES Act, can we just send out 30-day notices to all delinquent tenants? So far, we haven't sent out any notices at all. You could, if you want to do that. I guess, you're just giving a lot of extra time for those tenants that you wouldn't ordinarily have to do that for. That's certainly something that is an option if you want to do that, if it makes it easier for you as a property manager. Is writing in text acceptable by cell phone? I'm not sure what the question is regarding. You certainly can communicate with tenants via text message, but watch out what you are putting in text. I wouldn't put any agreements in text message. Anything that you put in text or email can be used against you in a court hearing by a tenant to say that you might have agreed to defer rent or not collect rent or something like that. So I recommend that you not be putting things in writing unless you truly want to honor that agreement moving forward. Because once you say, well, don't worry about July rent for now, well, a tenant could say they interpreted that you're waiving July rent. So just make sure that you're watching what you're putting in text message or email. Can you speak on week-to-week tenants? Do you have to do a 30-day notice, no COVID issues tenant? Not exactly sure that question, but I do understand that it's week-to-week. If they're week-to-week and you don't have a lease, you can terminate a week-to-week tenancy in Florida by giving a 7-day notice of termination. So that's probably your best bet. If you don't have a current lease and they're week-to-week, they pay week-to-week, then you can go ahead and serve a 7-day notice of termination. If you need us to help you draft that 7-day notice of termination, you could go ahead and reach out to us and we can assist you with that, Becky. My tenant is not paying since March. I started a 3-day notice, but courts were closed. Okay, well, I would recommend serving a new 3-day notice, assuming your property doesn't fall under the CARES Act. So if your property doesn't fall under one of those qualifications of the CARES Act, which we discussed at length, serve a 3-day notice for non-payment of rent, and then we can move forward, and the courts are not closed anymore. We can definitely file those cases. I would say one other thing you may want to consider, possibly, if your tenant now is perhaps their lease expired and they're a holdover and they never paid you any additional rent since their lease expired, or if they did pay you rent after their lease expired and they're month to month, we could go ahead and either do a holdover eviction or termination of month-to-month tenancy. That may be the better way to go to avoid COVID hardship defenses. So that's just something you may want to think about. Let's move on to the next question. Tenant owns a mobile home and rents a lot for the same month to month. Now past due on rent, go through the eviction process up to the point sheriff serves the eviction notice. At this time and point, is the tenant required to remove the mobile home and themselves from the property? So I want to not necessarily answer your question. I apologize. We don't get into lot rentals here and lot evictions. So that there's a different types of attorneys that do mobile home evictions for lot rentals. If it was only you renting a mobile home and not the lot, we could assist with that. It's the same Chapter 83 of Florida statute, just like all other evictions we've been talking about. But when it comes to renting a lot, you're going to need to reach out to a mobile home eviction attorney. There's a few of those law firms around the state, and you can Google one of those and find one of those to assist you with that. It's a separate part of Florida statutes and a separate area of the law. I got another question here. Now I gave them 30 days notice. Can I submit a small claim and try to recover some unpaid rent? I don't know what the 30 days notice necessarily has to do with that. Remember, we're talking about two different things here. One would be an eviction. So this webinar is about eviction. So if they're in possession of the property, they're not vacating. I've given you a number of different pieces of advice for different types of notices to serve on them to begin the eviction process. But once the eviction is over and they're out of your property, or they voluntarily moved out of your property, yes, you can file an eviction for damages. You can take them to small claims court or county court and try to recover damages from them. The likelihood of doing that is going to be slim. For someone who can't pay the rent, getting a judgment for damages for $5,000, let's say, they're probably not going to be too worried about that judgment right now. Maybe at some point down the road, they want to pay it off because they want to purchase a property and get their credit cleaned up. You could try that. That's certainly up to you. And you could go down to the county court and or download some of those forms online if that's what you want to do. Another question, what if a non-payment case, tenants are non-responsive and avoiding any contact with a landlord? What is recommended? Eddie, you want to take that on? So again, non-payment case, tenants are non-responsive and avoiding any contact with a landlord. What is recommended? What do you do besides just sending them to eviction? Any other procedures?
Well, we will go, I mean, we want to communicate with them. We will attempt to go and knock on their door. We will try just at least one last effort. In cases, we'll even try cash for keys, meaning that we'll go and say, we understand you're having, we've been trying to get, what's going on. We hear their response, and then they tell us the response. And then if it's appropriate, and we will potentially, as long as the owner is in agreement, we will then say, you know what, we'll give you $300, $500, whatever it is, to help with moving expense if you're out this day and you turn on the keys. If that doesn't go, or if the day comes and goes and don't move out, then we absolutely move forward with, if we haven't served the 3-day notice, most likely we move forward with eviction.
Yeah. And I would say one other thing, and I agree with you, Eddie. One other thing is, yes, maybe the first thing you want to do is knock on the door or call them, text them. If they're not communicating, sometimes having to serve that notice is what maybe will loosen up some communications, because they see that this is, the beginning of the eviction process. So hopefully by serving that notice, let's say it's a 3-day notice or a 30-day notice if it's under the CARES Act, that will hopefully loosen up some communication, get them to reach out to you. For everyone, just an FYI, we're going to take another maybe about 7 or 8 minutes of questions till 11:15, and then we're going to finish off the webinar here. You're welcome to stay for the next few minutes as we finish some of these questions off. For anyone that doesn't get your question answered, if you still have a question, you can again reach out to Eddie or I if it's regarding a best practices property management question about how to maybe get some help in managing your properties, which is what Eddie does, and helping to get some more rent out of your properties. Eddie can certainly answer those questions and help you. His email is there, eddie@pristinepm.com. Phone number is 305-400-4842. My email is there as well, thejaron@kellygrantlaw.com. Don't forget to put the E in Kelly, or else you'll get a bounce back email. And our phone number is 561-672-1161. A few more questions here. We have a handful of residents who didn't sign a new lease, but our lease rolls into a month-to-month agreement. This is not considered a holdover, correct? That is correct, Jill. That is not a holdover. They automatically turn month-to-month. Therefore, you would need to terminate their month-to-month tenancy. If your lease gives a specific way to terminate that month-to-month tenancy, some leases will say once it goes month-to-month, you have to give a 30-day notice, for example, then you need to follow that. If it doesn't speak on what type of notice is used once it goes month-to-month, then you can give a 15-day notice as long as it's outside of Miami. Next question, regarding the fees, are we still able to collect them later, or should they be waived, reversed from the landlord? We do not recommend that you collect on late fees or other types of fees through the end of July. The CARES Act talks about that. The governor's moratorium probably implies that, or there's arguments that implies that rent technically was not really late because there was a moratorium. There are arguments that can be made. Our recommendation, waive your late fees through July. Starting in August, you can start charging them again. That's our best practice. That's our recommendation. You know, if you're insistent upon it, then we'll give you the option to move your notice forward, but I don't recommend that. It is only providing a possible legal defense to an attorney that the tenant could get, or a legal aid attorney. Are you seeing significantly more evictions in these past 2 quarters than over the previous years? Not the previous quarters, because there was the moratorium. We weren't even filing many evictions other than for holdovers or lease violations or termination of month-to-month tenancy because of the eviction moratoriums. Now we are seeing a flood of evictions coming through. So yes, sadly, it's the state of the market and the state of our economy, but landlords do need their properties back, and we assist them with that. And again, if you need our eviction assistance, on our website at kellygrantlaw.com, you can click on Start a New Eviction and fill out our eviction intake package, and we can help you with that. Is there any protection for landlord who is affected by the CARES Act PPP decline my application? I don't, well, the one thing I do know about as far as funds, I know that Governor DeSantis had dispersed $250 million of funds to different locales throughout the state of Florida. You could check, for example, start maybe with your county, you know, if you live in Palm Beach County or in Orange County or wherever you live, start there. You may try to, you'll have to work your way through the system. I don't know which department would actually handle that. It could be, you know, the housing authority, maybe ask them, or go to your county or your city and see if they have any funds for you. Okay, I don't know which agencies have it, but there was some funds dispersed. Next question, if my properties are not covered under CARES, can I proceed with eviction? Again, that's a very broad question. I'm assuming you've been listening to the webinar. If you want to go back and watch it again, I should have answered that question based on a number of different factors, Doug. But if you are talking about non-payment of rent and it's not covered under CARES, you can use a 3-day notice, and yes, we can proceed. Even if it's covered under CARES and you want to file an eviction for non-payment of rent, just serve the 30-day notice, and once that expires, we can proceed. So all evictions can proceed. You just need to find out which notice that you need to serve. And then Carrie said, I closed today. So yes, back to your question, Carrie, then yes, if the tenants, you had a question about if a tenant's lease expires on Friday, then yes, then we can file the holdover on Monday. I have another question. I have a tenant that is month to month and owes plus month of rent. I think you mean more than a month of rent. Well, my recommendation is, because of this moratorium that allows for tenants to file COVID-related hardship defenses that could hold up your eviction, better to terminate their month-to-month tenancy if you have that option. So if you're outside of Miami-Dade and rent is due on the 1st of the month, serve them that 15-day notice and give them till August 31st, and then we can help you file that eviction on September 1st. Let's see, next question. Can we expect significantly more than 7% of people to claim hardships due to COVID? Out of the 93% mentioned who did pay rent over recent months, how many are likely to also claim the hardship? Brittany, we can't give you exact numbers. Obviously, you know, this is a whole new world out here. I can tell you that traditionally, depending on the county, depending on the type of case, maybe 30 or 40% at least of tenants would not even file a defense in an eviction, so they may not even respond to the eviction for a variety of reasons. And then of the ones that maybe do respond, 50, 60, 70% that do respond, somewhere in that range, depending if it's for non-payment of rent or what it's for, I don't know. I don't exactly have a number for you, but I would guess that probably at least half of them would mention COVID or losing their job or something that can be construed as a COVID-related hardship. So,
but Jaron, just a moment, I just want to add on to that.
Yep.
You had mentioned, though, they can now ask for verification. So if you, of that 7%, if they're saying, well, we're having challenges with the COVID-19, then prove it. How is it income down? So then they can provide documentation to support their hardship.
Yeah, agreed, Eddie. If we have a court hearing on this and we're representing you, the landlord, we are definitely going to give a passionate argument that the judge should require actual evidence showing that hardship. Last 2 or 3 questions here, and then we're going to shut down. 3 very quick ones, and then we will finish off the webinar. Next question is, what about commercial rental property? Commercial evictions can proceed with evictions, any type of eviction. The CARES Act and the governor's moratorium does not cover that. What if tenants try to stay past their lease end date? How does the landlord proceed? That is a holdover eviction. We talked about that several times here. Depending on what your lease says, as long as it doesn't automatically turn month to month or automatically renew, we can file the eviction and we don't need a notice for that, and we can file that eviction immediately, assuming you did not accept rent after the lease expired and create a month-to-month tenancy. Last question, is a duplex considered multifamily unit for the CARES Act? No, multifamily is 5 or more units under the CARES Act. But if your duplex has a federally backed mortgage or you have a Section 8 tenant in there, then you would fall back under the CARES Act, okay?